And good afternoon again. I'm Roger Watterson, and now it's the Sunday Mannin line. We're here just a few minutes early, and we're here to talk about anything that you would like to talk about. The telephone number is 66 13 68. You can text to 166 177, or you could email to studio@manxradio.com. And we have with us in the studio Jane Gray, who's president of the Isle of Man Law Society. She was our guest on Sunday Opinion, and we were talking about the idea of setting up a public defenders department. And of course, as you may have gathered from that the Law Society is not very keen on the idea. But that was theirs. But the department looks as if it's going to go ahead. That is, if Kitun will give its approval. So we may come to that again in a moment. And with her is Manx advocate Terence McDonald. He's in the studio with us now. So have you got anything that you'd like to talk about? Not just the SAVE scheme, but any other matter, legal or otherwise. You can't talk about your personal cases, but we can talk about issues. So the number is 66 13 68. That's where we do. And we will one or two advert breaks. But before we go to the break, I've got one here from Anne Kelly. This is the first of our emails. And she says, "Good day, Roger. Can you ask your studio guests why the Manx community is being obstructed by the Law Society in using the law of the land mentioned above that was raised to check and balance a rogue government and judiciary and make them accountable for the ill treatment of the people, please?" And she's talking about the Human Rights Act 2001 and other acts that protect the nation.
That's a rather confusing question, but the only point I would make, because I must confess I don't quite understand it, is that advocates are here, lawyers are here to protect the public. The state, it's the state, in fact, who regulates the public. We, in fact, are here to protect the public. So I don't quite understand the question, but I'd like to emphasise something which my learned friend said. Where let's make it clear, we're not against, as such, we wouldn't be against the public defender unit if in fact we thought it would protect the public. Our view is it won't protect the public. There is no doubt about there is no doubt about this. I mean, as my learned friend Jane said, if this goes ahead, we'll have civil servants. Now, I'm not criticising civil servants. We have some wonderful civil servants, but in life we have those who perhaps aren't as good. But we're going to have the police detecting crime, the prosecution department or unit prosecuting crime, and civil servants defending crime. Defending defendants, and then, as my learned friend said, then they will go into a prison run by the state. Now, in England, when they set this system up, as Jane has said, it would alongside the normal the normal legal aid system. You could actually choose. We won't have that, and I think that is a big problem. It's probably one of the biggest problems which we're going to have with it.
Right, okay. Now, that's and on a number of occasions, says Chris, I have approached local firms of advocates to try and progress some legal work. Some have extended me the courtesy of replying, but others declining, and others haven't returned my calls. Overall, I've come to the conclusion that local advocates can afford to pick and choose what work they wish to pursue. I would like to see a system whereby once a resident of this isle has been declined by 3 local advocates, they automatically have the right to try and seek legal representation from the UK. Legal representation should not come under the umbrella of a closed shop. Well, you can't you, with licence, go to the UK if it's felt you can't get representation locally?
Only in special circumstances, and certainly you wouldn't get legal aid to go across. Okay. But I find again, when they say that lawyers can choose their cases, yes, they actually can, which is why, as Jane said, lawyers who do criminal law, they choose to do it. They could do far more lucrative work. So there's no such thing as fat cat lawyers, because there are 21, 24, 25 lawyers who are prepared to work for less remuneration than they could doing other jobs. But if anybody has a problem in getting a lawyer, they can contact me at Mannin, and I will assist.
Can they contact the Law Society as well?
Well,
does the Law Society send them to people?
The normal procedures is you would go to the Law Society, and the Law Society has a panel of advocates, and that they would be able to point you in the right direction, depending on what it is, the legal advice that you need.
No, we're talking about legal advice, but in every organisation you always get somebody who doesn't perform too well or makes a pig's ear of something or gets it wrong. Where does the public go for restitution, for response to that? Is that to the Law Society?
Well, within the individual firm as to where that advocate worked, there will be a complaints procedure, and that will be highlighted to the client when they first come to make an appointment with that particular advocate. If that is not successful, then they are then able to approach the Law Society, and the Law Society provides a conciliation service with a trained conciliator where both the parties can actually sit down and air their grievances and views and trying to resolve those issues around the table discussion. If that doesn't work, then they also have the option to make an official complaint through the advocate's disciplinary tribunal. So there are certainly a number of channels should clients be unhappy with the service that they have received.
I've heard some people say, well, that's all very well, that's the system, but they look after themselves.
No, they don't. Look, well, when I arrived here 30 years ago, this is what people said, that advocates look after themselves. They don't. Advocates are quite prepared to sue other advocates. This is a mirage. We do. If in fact it's in our interests, if an advocate is negligent or is not coming up to par, it's in our interests to actually ensure that if a member of the public has in any way not been properly represented, it is in our interests to actually do something, and perhaps it could happen that that particular advocate could be struck off.
Right. Okay.
Or we can provide training.
Mm.
But that is one of the roles that the Law Society undertakes, is training for its advocates, making sure that they are providing a good service, that they are regulated properly.
Who license advocates? Is it the Law Society?
It is the Law Society regulates all the advocates within the island, and as a regulator, the first concerns is obviously the protection of the public.
Right. Well, we're getting one or two more texts and emails coming in now, and a phone call or two. So we'll take our first break, and after the break, we'll take our first call. And welcome back to the Mannin line. Our studio guests here are Jane Gray, the president of the Isle of Man Law Society, and advocate Terence McDonald. And we have our first caller on the line now. It's David Quirk. Good afternoon, David.
Good afternoon, Roger, and to the panel. I've been listening to you while cutting the grass in Blackberry Lane there, so I've been listening to it hard. And I have some sympathy with the lady that's been expressing a particular view there, and I'm not connected to any way to lawyers or have anybody in the family at all before anybody whinges at that. That is, they do a good job and a good service. The problem is with people at the end of the day, when I think they see an advocate, is the advocate sometimes tells them the truth and says to them, well, did you do it or didn't you do it, or what mitigation there is? And I just wanted to ask if we, and put a little sounding board out there, because I worry about our Parliament at the minute not chasing different things, asking those questions. If the scenario goes and it drops the bomb in there, and then the lawyers are then asked to rekindle it back up again, what's going to be the risk to justice on the island, as they would say? And also, can I just ask...
Wait a minute, can I just stop it? What you're saying is, if they go, is this to do with the public defenders?
Yes.
In other words, if they do it and it fails, what's the result? Well,
it's like, and I wouldn't blame them. If you were doing something and you had a contract, like you have a business, you were doing work for something, and then they absolutely pooed on you, and they came back, you say, well, Roger, would you do it again? Wouldn't you think twice?
Might at a different price.
Yeah, but then the public purse then goes up. So what we were trying to achieve actually goes down and makes it even worse. Right. And the final thing, just can I say too, the risk would be, I presume, I'm not putting words in people's mouths there too, that the solicitors also do or sit on panels, which are Social Security appeals panels. There are a number of them, and they do that with an independent person, some from the employees and some from the construction industry or whatever. But they do have those panels as well. What will happen to them? What's going to happen?
I wonder if I could do with that, because Jane touched on it. As I say, we have at the moment, I'm not sure whether it's 20 or 21, but at least 21 advocates who do criminal law. Most of the cases are in the summary courts. Now, if the summary courts are going to be dealt with by the Public Defender Unit, there won't be sufficient work for these criminal lawyers. So they will have to, even though they choose to do less lucrative work, they will have to choose other work. So if there is, well, when the problem arises, when the chaos appears, there will be no criminal lawyers able to assist, which is why our fear is that they'll have to go to the UK for expensive UK barristers.
But even if they've moved over to doing something else because their line has dried up, they're still there though, aren't they? Or are you saying there's nobody coming along the line to train?
They will still be there and they can come back, but what about those young advocates coming up? The summary courts are certainly a training ground for those advocates, for creating the training, for the skills and experience, and if that opportunity is not available to them, you won't see a junior advocate who's just qualified going up to the Court of General Jail delivery. Where will they get those experiences and skills from? And that pool will just over time be obliterated and degenerate, and maybe in 10 years' time, how many criminal practitioners are we actually going to have on the island?
Is that your point, David?
It is the very point. Can I just ask about mediation too? Because when I was in Parliament too, there were instigations that young advocates coming forward there were going to be used on for mediation services, appeals panel, just to say, like an apprenticeship, break their teeth in. You know, when you get wiser, like that gentleman that's sitting in your studio now is really wise and has lots of knowledge.
Yes, I mean, the tribunal is certainly a good way for training and junior advocates to actually get those experiences. You don't have to be a qualified advocate to represent somebody in an employment tribunal or social
appeals.
Exactly.
Yeah.
But that's not criminal. And for criminal, they really do need to have that experience within the summary courts.
Yeah.
And without that, they're not going to be able to be able to represent their clients efficiently.
And the final risk, Roger, sorry to cut across you, the final risk is, Roger, if it's put in the AG's office and then civil servants are doing it, and not all the civil servants are tarred with the same brush, sometimes there's a risk. There will be more of a risk than it would be if it went to the advocates.
I think actually the plan was that it would not be in the AG's office. It's going to be in a separate office somewhere.
Well, can you say on a small island, people talk?
Yeah, okay.
You'd be surprised how many people are in Apple Street talk in coffee shops.
If I can maybe just touch on what you've said there, David, in respect to the Public Defence Unit and the number of advocates which they're proposing to put forward, which is 6. It was only in TT week that we had a 15-handed fray, and each individual defendant would need an individual advocate. And I've attended only a number of weeks ago a 500 juvenile matter. How is that actually effectively going to work? Does that mean that there's going to be somebody out there that's not going to have representation within the summary courts, that they're going to have to actually represent themselves without any knowledge of the law at the time?
Well, David, well, look, I'm pleased to say we have another couple of calls on the line. And Terence is waving at me here before we go. What did
Just
you say?
Before you go, David, in fact, you probably haven't seen it, but the report which is going to Timbled, on that point, it says, a robust solution to the conflict of interest which would exist between HMAG's prosecution team, government departments, brackets who may be defendants in the cases, and the PDS, the Public Defender Service, will need to be found in order for the PDS to be able to perform its role, and in order for it to be accepted by the public. It will be crucial crucial to ensure that sufficient governance exists over the process to ensure it is successful. And then it goes on to say that another government department, not the AG, will be looking. Well, it's still government. It's still government. And will these civil servants be
qualified?
Well, no. Will they be under pressure?
Yeah.
To make savings? Jane mentioned the problems with disclosure, where numerous cases have collapsed, arguably because the prosecution say they've been too busy to look at it. Well, when it gets to the defence, will the defence advocates will they be too busy?
So there's a series of peripheral questions. Anyway, David, we have another caller on line, so thank you for joining us. Thank you.
Thank you, David.
Thank you. Bye-bye. Yes, that was David Quirk. Just to mention here is why not a fixed fee for defence rather than an hourly rate? The judiciary have in past criticised defence advocates for unnecessarily elongated proceedings.
Well, what we found in jurisdictions where they have used fixed fees, and if I can mention Scotland, that they had introduced fixed fees for solicitors attending the police station. However, those fixed fees were at such an extent that actually the solicitors weren't able to continue receiving those fees. They were quite minimal, and the costs of actually getting to the police station, they were fixed fees. So if you were at the station for 10 or 11 hours and you were getting something like £60, it just wasn't working. And solicitors said, look, I'm sorry, but we can't do this. And that was why the public defender scheme was actually first introduced in Scotland, to be able to provide solicitors to represent defendants at the police station, because they didn't have the solicitors available.
Right. Okay, now our next caller on the line is Chris Robertshaw. Good afternoon, Chris.
Roger, good afternoon. I have to smile. It's not often David Quirk and I find ourselves on the same page, so a remarkable happening. But he actually, as I was listening, I asked some of the questions that I was going to ask, particularly with regard to if subsequently we do find it's a serious mistake adopting a public defender, where would we stand in 3 to 5 years if we then tried to reverse back to where we were? And I think the answer's been given. So let me ask perhaps a couple of other questions. The concept of the public defender seems to be maturing at an alarming rate. Can Jane advise your listeners to what degree government has engaged in careful and detailed consultation with the Law Society up to now, prior to arriving at this position?
Well, what I can say is that there hasn't been any consultation. What we've had is a meeting by the Attorney General stating this was a decision that was going to be implemented, and legislation was going to certain changes in order to implement that proposal. Since that time, we have been trying to find the information as to what the Tynwald has actually based or will base their decision on, and we haven't received that. We've also not received the reviews from the consultation that took place with the Legal Aid Committee when they first looked at this last year. And we've pretty much just been sidelined, even though we're one of the main stakeholders within this situation. It's very disappointing, really, that we've always tried to work with government departments and also the Legal Aid Committee to try and provide the best service that we possibly can to members of the public to make the scheme more efficient. Advocates are very mindful of the fact that legal aid is money coming from the public purse, and where we can feel that savings can be made and matters more efficient, then we will actually put that forward. But unfortunately, in this particular case, there's been no consultation at all.
Thank you. Jane, did I understand you correctly there when you said the AG said to the Law Society that this would be going ahead, or did I misunderstand what you said?
Well, it was intimated to us that this was a decision that was going to be made, and legislation, certain changes were going to be made in legislation, and whether we're right or wrong on this point, the impression that we received was that this was a done deal.
you might think from that it's not perhaps just the Law Society and the legal profession that's been bounced, but a suggestion from what you say that there's a possibility there's an attempt here to bounce Tynwald in the same manner, which obviously is very alarming. My second and final question. Where you've got a situation where a defendant comes before the court in relation to something which is an alleged crime against government personnel or government properties or systems or whatever, that effectively means that the crime committed is related to government, the prosecution is raised by government, and the defending process is then enacted by government. Just in international terms, bearing in mind, how small a jurisdiction we are, do you think that would stand up well to international deliberations or inspection? Or do you think it would create confidence internationally that we were a viable jurisdiction from a legal perspective and justice perspective?
It is that public perception of independence, and the fact that you do have to have that division between prosecution, defence and the courts, and whether actually defendants are getting the best possible service that they can. But the Law Society's argument is that we're actually a very small jurisdiction here. We often suffer with increased areas of conflict of interests, and that's the concern. The Law Society's concerns are along the line there are going to be members of the public out there arrested or on suspicion of committing offences which they may well not have committed, and they may end up finding that there isn't adequate representation there.
But,
Thank you very much indeed.
But Mr. Obershaw, to deal with your specific question, it stands to reason that the public are going to be suspicious if in fact all the parties are government departments, all paid by government. People, whether rightly or wrongly, they will think that the pressure could be put upon the defence unit, and that is a big worry. Once the public lose confidence in the law, well, we're in North Korea or in Russia, etc.
But what we would be saying is that would be a perception of the public. Obviously, these particular advocates would be working in the best possible way that they could for their clients, whether they work for the government or in private practice. But what is often found is they are, at the end of the day, government employees. They may well end up finding that they have certainly a high workload, and they may find that they're getting pressure from their employers, especially if they have impossible caseloads and cuts in resources and understaffing. And this is what we've seen happen with the disasters in the US, that there was actually one particular attorney that did petition the court to say, look, I can't actually carry on representing my client because I'm so under-resourced and overworked, and he wanted a release in respect to that representation.
Right. Okay, well, Chris, you're going to have to be debating this on Tuesday.
Yes, well, I'm concerned that there seems to be the suggestion that this is maturing quickly, because my understanding of the submission that's coming to Tynwald on Tuesday, and I obviously from my questions I do have serious concerns about this particular item, that it is actually a progress report that we're being asked to consider, and I hope it does turn out that when Tynwald is asked to debate it, that we are clear that this is just a progress report. We're not ticking the box and saying this is going to go ahead or we approve it. It is just simply and no more, in my understanding, as a progress report from the Treasury Minister. And effectively, from my standpoint, I see this as an opportunity to seriously open this debate now about a public defender and enter into proper processes regard to consultation and proper examination of costs, etc., before we dare go any further. So I hope it's only that. Thanks, Roger.
Okay, well, thanks for joining us, Chris. Thank you.
Bye-bye.
Bye-bye. That was Chris Robertshaw. Now, we've got one or two more, well, actually quite a few texts and emails in, and another phone call waiting. But before we go to those, let's take a break. Welcome back to the last part of today's Mannin Line. With me in the studio is Jane Gray, who's the president of the Isle of Man Law Society, and Manx advocate Terence McDonald. And we've been fielding some calls and dealing with some texts and emails, one or two more calls coming in. So please let us have them. We're another 14 minutes to go, so let's see if we can get as much in as we possibly can. Chris says too that during the course of the dialogue relating to this programme, I keep hearing the word government and the potential of conflict of interests. Are not the judges of appeal appointed and paid for by the government? Would it not be a better system if a visiting UK circuit judge would act as judge of appeal? Now, they do bring in special judges of appeal as acting deemsters, isn't it, when they come in?
Well, in actual fact, until in this year, the appeal, what used to happen in relation to appeals is that basically we had two judges. We have assistant judges, and we also have Deemster Montgomery. But we had the first Deemster and the second Deemster. The second Deemster would mainly deal with criminal matters, which in fact are now dealt with by Deemster Montgomery, who I might say is well thought of both by advocates and by defendants. You know, defendants feel that they get a fair deal from him. Anyway, sorry. Coming back. So what used to happen is that if it was a criminal matter, the appeal court would consist of first Deemster and an acting Deemster from across. So you'd always have the so-called well, if you want to call it independence, I mean that there would be an English judge. We've now, in fact, got a full-time appeal Deemster who is living on the island, and there won't be any input from the UK. Now, my own view was that I thought it was a much better idea to have somebody coming from England, because not that I felt that there would be any influence, but again, it's public perception. And this particular person who was telephoned and was raised the particular issue I and other advocates were concerned with. So now, no, it would appear that there'd be no input from England. In relation to,
but surely, I mean, I can understand the public perception about something, but surely, if one is at that level in a legal career, you can rise above that.
Of course you can. Objective. Oh gosh, I'm not saying. Look, of course you can, but it's public perception again. This is what's important.
Right.
You know, I am quite sure I wouldn't have any qualms about thinking a Deemster couldn't rise above it. But this particular member of the public has raised the issue.
Okay. Now, we've got another caller on the line now, and it's Stephen. Hello, Stephen. Good afternoon.
Yeah, good afternoon, Roger. Good afternoon, panel, and good afternoon, listeners. Firstly, I'd like to congratulate the Law Society for flagging this very important issue up and raising it, because if we don't have confidence in the law, then we as a country have nothing. And I think, firstly, well done for doing this. And I think this shows the impartiality of the law and the Law Society by flagging it up, because lots of times you hear round the island that the Law Society and the government work hand in glove and there's no opposition, no intelligent opposition. So I think this has highlighted that there is, and you should be congratulated for that.
Thank you.
That's the first one. Secondly, I think it's what Terence and the President has said, that you can't have everybody working from the same stable. That seems to be one that most ordinary people that are not well educated can understand. And I think for the government to suggest this can happen seems to be bizarre. But when you look at the narrative coming out of government, they, forgive me for saying so, but they seem to not given this subject the weight it deserves, because they're taking the buses in, they're taking this in, they're taking that in back in-house. And this seems to be part of the narrative. Now, what I think is shocking is that the president of the Law Society said before is that you've had no proper consultation. And for something so important, this seems to be absolutely shocking to me that there's been no consultation with the people, the experts on the issue. So I think that's amazing, to say the least. But secondly, what I'd like to say, and I think this is probably not questions to the panel, but my observations is that it's one thing having a consensus executive, a consensus Comin. It's quite another to have a consensus Tynwald and a consensus House of Keys. And I hope that this subject gets the intense scrutiny that it rightly deserves when it's brought before the House of Keys. I hope it's rejected and it's given the short shrift it should deserve.
Thank you, Stephen. That's exactly what we're looking for. If we look at the Jersey, they'd spent 18 months in full consultation with all stakeholders when they were looking to review their legal aid scheme, and ironically, they actually implemented the scheme based on the Isle of Man legal aid scheme.
All right, Steve. Well, thank you for joining us once more.
Thank you, Roger.
Cheers. Bye-bye. That was Steve Moore. Albert Rowland is a little bit up here. He's not too keen on things. What's all this about having to otherwise go across for expensive barristers, he says. 10 years ago, some of the Isle of Man bewigged ones were charging in excess of £350 an hour. And I was advised by Mark Maroney to try for an English barrister who would be £500 a day. As the saying goes, do the maths. It's about time the Isle of Man, the legal industry, got rid of its greed and exposed what it is, a hugely powerful money-making cartel.
Look, we've made quite clear that criminal advocates get at least 2/3 less than commercial lawyers. They choose to do it. So with all due respect, I don't accept that. The reason I talked about expensive English embarrassment, and because as Jane has already said, and I hope I've emphasised, there will be no advocates on the island who will be doing criminal work. The older ones will have actually died, and the younger ones wouldn't have had the experience.
Okay. Now, Damien is now on the line. Good afternoon, Damien.
Good afternoon, Roger, and good afternoon, panel.
Oh, good afternoon, Damien. Thank you.
Good afternoon, Damien.
Hello. Yes, I would like to pick up on a few key points that are of great concern. I'm a commercial law practitioner. I don't practice the criminal bar, but I must say I've been very alarmed by what I've heard today on the radio, and I think some of the contributions, particularly those of Chris Robertshaw and Stephen, who spoke a little earlier, are very important. I'd just like to pick up on a few of them. I think from a public perception point of view, there are serious concerns about the loss of independence of the criminal bar should it basically be taken over or effectively nationalised by the state and run by a government body. I think I would like to ask whether at this stage there have been any proposals as to how conflicts of interests would indeed be managed and how that defender unit would be regulated, given that historically difficulties at the Attorney General's chambers have required the input from the United Kingdom. And I would point in particular to the Wooler report, which was commissioned by Alan Bell, the former Chief Minister. And I fear that effectively not only would we be losing our independence in terms of the criminal bar, but if there were any serious issues, they would be either politicised here, which would compromise the representation of defendants, and or require external UK input. I wondered if the panel had any thoughts on that.
Yes, I mean, and as I raised earlier, this report, in the Law Society's view, is fundamentally flawed in the fact that they feel or consider that this scheme can be replaced by 6 advocates. That's not dealing with any possible conflict of interest. As I stated, there was a 15-handed affray in TT Week. I also dealt a few weeks ago at 5-handed juvenile. where there's been no consideration to conflict of interest in that respect.
I see. So, in fact, at this stage, it sounds as if they haven't addressed their minds, addressed these issues, and it's going before Tynwald for what appears to me to be a premature consideration on Tuesday, before key fundamental and constitutional issues have been properly considered, even in outline.
When you look at who were the actual persons behind this report, so you've got members of Tynwald, you've got the Legal Aid Committee that is one of the main drivers of this report, but you only have to look at who sits on the Legal Aid Committee. There's no member on that board that practices law. There's no Manx advocate. There's no one with any experience in the legal aid industry, and you can see that even in the Save Scheme report that they seriously acknowledge how the programmes and systems work.
Damien, while you're a commercial lawyer, you'll be aware that in terms of criminal cases, where there is more than one defendant, they often blame each other. They have different stories, and what happens in that case is a lawyer from one firm will represent defendant A, and a lawyer from another firm will represent defendant B. Here we're going to have people probably sitting across the same desk, defending both people. Of course, there's going to be a perceived conflict. And
the other issue as well, that defendants will not have the option to choose who they want to represent them. They will have no choice if the whole of the summary courts is covered by a public defence scheme. They will just be left with that particular advocate on that particular day, and that's the choice of which they have nowadays, and that will be taken away from them by the government.
Sorry, Damien. Bar, really.
You know that lawyers get work and reputation. Now, I'm not criticising any civil servant who's acting as a defence advocate, but the point is they won't have to build a reputation. They won't, because they are guaranteed their pay. They're guaranteed their pensions. If you're not a good lawyer, whether you're a criminal lawyer, a civil lawyer, if you're not good, you won't get any work. The criminal defence unit will get work whether in fact they're good or bad.
And we have to say thank you for joining us, Damien, but we've literally run out of time. We've 30 seconds before we go to the news, but thank you for making your comments.
Okay. Thank you, Damien.
Thank you.
Bye-bye.
Bye-bye.
Right, that was Damien, and as I just said, we're right at the end of the programme now. Our studio guest has been Terence McDonald, who was an advocate, and Jane Gray, who's also an advocate, and she's the president of the Isle of Man Law Society. Well, thank you both for coming along. That's great. There's one email just popped in here that says, what scrutiny is placed on legal aid bills for advocates who may abuse it by sending letters and charging for things that are not required? These are all taxed, as they say.
There is great scrutiny. In most cases, when I did in criminal law, you were paid probably 2/3 of what you had claimed.
Okay, that's good. Well, that's the end of it. Catherine Nicholl is on the switch today. I'm Roger Watterson. I'm not here next week. Catherine will be, but I'll be back the week after. Until then, goodbye.
Bill.